Laura, take us through this news.
What's probably most striking about it is how much was done and how little answers they came up with. They basically are empty-handed after nearly 8 months of investigation. They went through who had access to it digitally, who had access to this opinion in hard copy. They went and they tried to track down the printing logs. They tried to use fingerprint analysis. And yet still, after all of this work, after all of this exhaustive work that's not laid out over 18 pages, no answers about exactly who's to blame, which is pretty incredible. As you laid out, the stakes here so high for the court. So much of the court's business is operated through a system of trust, a system that's shrouded in secrecy. Law clerks know they have an obligation to guard this with their lives, or their entire careers are on the line. And even with all of that, they conduct all these interviews and they can't figure out who did this. And interestingly, nobody declined to talk to them, which is worth noting. They don't think it's a hack, which is worth noting. They looked into that probability. So really, very little insight. And it appears that this is the end of the road. They say here they're going to follow up on a few things, but you get the impression here they've done everything they can do, including getting an outside consultant from the former Homeland Security advisor who said they think they've pretty much exhausted all their efforts here.
Well, I mean, it's knowable. So did they interview the justices?
Well, it's interesting. They say they talked to, obviously, everybody who had access to the document itself, which would presumably include the justices, but they don't really go into that in this report. They do say that there's an annex here, which they're not including. Maybe that could shed some light on it. We just don't know. It's clear that they were very focused on court employees and law clerks. They thought that that might be the likely culprit. But even that, they don't have answers. And it's worth noting, I think you get a picture here of how unsophisticated sort of the technology is. When you and I are printing in this building, we have to use an ID card. Mm-hmm. There's a whole log to it. That's not happening here. They don't have even a log of who's exactly, taking things when and where. And so I think one of the things you'll see coming out of this is probably a much tighter grip on how these opinions are distributed. Because in the past, it was sort of, again, a system of trust. But because that trust has been broken, I think you'll probably see a lot more changes.
I want to add to our conversation Supreme Court watcher Dahlia Lithwick, legal correspondent and senior editor for Slate, host of the Amicus podcast, as well as an MSNBC law and politics analyst. She's also the author of a new book, Lady Justice, Women, the Law, and the Battle to Save America. Dahlia, your take on this breaking news?
Yeah, I mean, in some sense, unsurprising. I think that the decision was taken to do this in-house using the Marshal Service. Probably other choices could have been made to have a different, perhaps more thorough investigation. But I think the takeaway is exactly what you just heard, that for a leak that was characterized by most of the justices as the single most shocking, egregious violation of norms of trust, it's still being credited for destroying collegiality amongst the justices. This was a nuclear bomb that went off at the court. And now the answer seems to be, so sad, too bad, we don't know who did it. It's pretty amazing in light of how absolutely consequential this has been, not just for the justices amongst themselves, but for the sort of integrity and reputational interests of the court.
Frank, if a sitting United States Supreme Court justice believes that a leak could directly lead to his, quote, assassination, why would the court's marshal conduct the leak investigation?
Lots of questions here, no answers. When is an investigation really not an investigation? When you're told what you can and can't do. You can't do what you need to do or talk to the people you need to talk to solve the investigation, and when the investigation isn't conducted by professional investigators. Let's level set here, because there have been some things said that I think we need to clarify. Number one, the U.S. Marshal Service did not conduct this investigation. This investigation was conducted by someone called the Marshal of the Supreme Court. I'm sure she's a wonderful person, but she has no law enforcement training or experience. She's in charge of securing the building called the Supreme Court building and its justices. That's what she does. That's who they gave this to in this most egregious breach of security in history of the Supreme Court, allegedly, as the court statement says. Something else that didn't happen here. if you want to do a real serious leak investigation, you're going to talk literally to every person who may have had access to whatever it is that leaked. From what we can see so far, while they may have talked to 100 people, they didn't talk to ex-clerks. They didn't talk to the very universe of people who may have done the leaking and then left the court to go on to, as they all do, some great legal job. They didn't talk to those people. They didn't call the FBI because you know what would happen? Then a real case would have happened. They would have actually had criminal process. Someone stole government property. Someone mishandled government records. Potentially a crime. They could have had subpoenas of former clerks and former employees. They would have had that leverage over them. They could have subpoenaed phone carriers and internet providers, and they could have seen who was talking to whom and when at the media platform that obtained this information. All of that could have been done. We still have, according to the New York Times reporting today on this, we have no evidence that the justices themselves were interviewed. And let's understand something. This person called the Marshal of the Supreme Court, her boss is the court. They pay her salary. They decide if she gets a raise. So what would that interview even look like if it was done? Mrs. Justice, you're wearing a lovely brooch today. Could I trouble you with a question? You don't know anything about this silly leak thing, do you? And I'm not implying that you might. And by the way, since I've got you here, I would like a raise next year if we could talk about that. That's how that would go. So this is not an investigation, and there's no serious intent to get to the bottom of it, in my opinion.
So why would a sham, I mean, what you're describing is a sham investigation, why would a sham investigation be ordered if Justice Alito felt that his, quote, assassination was possible because of the leak?
Well, since we're not in the conjecture business, let's answer it generically. Why would you curtail an investigation, right? And I want to say something. What I've read about this investigation is that within its parameters, and boy, those were significant parameters I just described, it was a heck of an investigation, right? They tried to look at printers and forensics and IT, and they conducted 100 interviews. So not a sham, but rather an extremely curtailed investigation that really wouldn't get to the truth. But generically, why would you curtail and put those handcuffs on somebody investigating what happened? Because you don't really want to get to the outcome. That's why.
Did they want to get to the outcome?
Oh, I think they do want to get to the outcome. I think the court feels very much invested in having an answer here. I'm sure it was not a pleasant experience to have to issue a report that says we have no answers. The court feels very much that its legitimacy is at stake. It feels very much rocked by the sort of shaken about the trust that was breached here. Mm-hmm. They call it the worst breach in the court's history. So I think they do want to get to an answer. The question of how they went about it and whether there was other steps that they could have taken, I think are fair questions to ask. I should point out that they say that they used a team of seasoned attorneys and trained federal investigators. We'll have to do some reporting on exactly who those people were and what their level of experience were. But I think there's no question that the court has a vested interest in getting to the answer of who did this, because then they have someone to point the blame at.
But if they thought their, quote, assassination was like, why not send it to the FBI to investigate?
Yeah, and that is certainly a fair question. And, you know, there's nothing to say that they won't do a follow-up on this. There's no reason to think that if they get some new piece of information or something comes to light or someone comes forward, that they wouldn't follow that lead. Again, I think that they...
But just to be clear, the report has no leads.
Yeah, no,
there's nothing to follow, right?
For
just
now.
Just to be clear about what we know.
No.
There's a report and there's no leads.